Ini untuk isna ini. Apa kan mau? Hah?
May please, my lord. My lord, I beg to mention item number 4. Well, here we have just received instructions to appear on behalf of the respondents district council for respondent number 4 and 5.
Oh,
My lord, yes.
yes. What happens? Which is new consoles.
New consoles.
See, this matter is already part heard. Part heard means where is that part now?
Earlier, senior counsel Mr. Kunta was appearing for this council.
Lordship, after the reshuffling of the district council, Lordship, now Learned Senior has been appointed.
Of course. Two weeks.
2 weeks. I'm praying for 2 weeks' time, my lord.
Mr. City Sangma, Learned Council, has submitted that he is entering appearance on behalf of the respondent
4 and 5.
4 and 5 oblique KHDC
KHDC.
and has sought for time to be heard in this matter. It may be reminded that this is a long pending matter and the parties are requested to ensure that the same is heard expeditiously. 2 weeks?
Make it 3 weeks, my lord. In the meantime, the petitioner supplies a copy of the petition, my lord.
We'll supply, ma'am.
No, you should have your brief with you.
My lord, the thing is that I think they have not received the brief. So that's the difficulty, my lord. So in the meantime, just pray the petitioner will supply us a copy of the petition.
On pre-made, let's just matter the 3 weeks.
Obliged,
But I think that will be the last chance.
my lord.
You get your things ready by then and we'll proceed.
And
Lordship, I beg to mention item number 3, Lordship, of the main list, Lordship.
This also
Lordship, part heard. This is part heard, Lordship.
part heard.
Part heard, Lordship.
Then
Lordship, some difficulty on the part of Learned Senior, Lordship, today. I'm praying, Lordship, if this matter comes
this
next
is
week.
see, this is the oft-repeated refrain.
Lordship.
Every time you will come difficulty. We understand, but then you have to make arrangement, alternative arrangement. If you are not very keen in contesting the matter.
Lordship.
Now, 2015 matter.
Lordship, I'm seeking indulgence for a week, Lordship. We'll ensure that the matter is taken up on the next date.
Now, again, this matter is was also part heard.
Lordship.
Then you have to start all over again. Yet again, Mr. Learned Counsel has made a plea for accommodation in this matter on behalf of the Learned Senior Counsel, Ms. E. Paul, who is said to be indisposed on grounds of personal difficulties. The plea not be objected to by the respondent. The same is allowed. It is next, considering the fact that this is a long pending case, a very long pending case, it is requested that the parties make endeavor to pursue with the matter diligently. As prayed for, this is matter up to 1 week.
Lordship, I'll be obliged.
Supplementary list, item number 1.
My lord, we are withdrawing this application, madam.
Withdrawing it, simpliciter.
My lord, we are filing afresh, my lord. Through proper channel, my lord. We are filing a proper channel, proper petition, my lord.
That has got nothing to do with this.
My lord.
Nothing to this. No, nothing to be recorded.
Ms. Sarkuni Learned Ji has submitted that under instruction, The
AG.
Instruction, my lord.
the this appeal has not been admitted, no?
No, my lord. We are at the stage of the miscase, my lord.
Delay continuation.
The petition being MC under bracket FA number 4 of 2024 is withdrawn. Is withdrawn. As such, necessary orders may be passed with this court. On consideration of the submission made, this petition, along with any related anticipated, along with the related anticipated appeal file, is hereby dismissed as withdrawn.
Much obliged.
On daily list, item number 1.
Please, Your Lordship. Lordship, this appeal is fixed for admission today. Fairly straightforward appeal, my Lord. If Lordship allows, appeal can be admitted, fixed for hearing, my Lord.
Yes. Mr. S. General, counsel for the appellant has submitted that the appellant, you are aggrieved by what?
By order dated, my Lord, 12/9/2022, my Lord.
By judgment dated 12/9/2022, passed by the learned
MECT Tura.
member MECT Tura, has approached this court by way of this appeal. Being aggrieved, ngalaong ni. With the has now approached this court by way of this instant appeal. It is prayed that the same may be admitted. Mr. A.H. Hazarika has accepted notice on behalf of the respondent. You are respondent number?
1, my lord.
Respondent number 1. So you have to take steps for 2, 3.
My Lord, those steps have been taken. If Lordship looks at order dated 18th February,
Whether they have received or not.
18th February, my Lord, towards the end, last paragraph, that is ex parte against number 2. And order dated 5/12/2024, my Lord.
Just
Yes, my Lord. So, order dated 18/2, it's gone ex parte against number 2.
yeah, how to shit you money. You see. Then we got to the miscase. Was there a miscase?
There was a miscase for condemnation. That's allowed.
Condemnation.
That's allowed.
So the order of to proceed ex parte was finally passed in that
No, madam.
in the main case.
Looks like the miscase action, my lord. Miscase. In the miscase, my lord.
But that would apply only as far as the miscase is concerned.
Yes, my lord.
The same order would
Not
apply.
the main case.
I cannot be asked to take steps again for the main appeal, my lord. Order dated 5/12, my lord. 5/12. Sorry, prior to that, my lord, order dated 18/2. 18/2. If lordship looks at the second last paragraph, ex parte against number 2 shall now proceed ex parte against respondent number 2. That is number 2. Now order dated 5/12, my lord. In the same miscase.
Yes. Yes.
Uh,
512.
512, my lord, 5/12/2024. In the same case.
Yes.
If I'll read, my lord, Mr. S. Jindal, Learned Counsel, so and so, has submitted that the notice issued upon respondent number 3 may be deemed to have been served, inasmuch as the notice has returned with a noting that the same was refused to be accepted by the notice receiver. An affidavit of service in this regard has been filed. As far as respondent 2 is concerned, since service report has not yet come, it is prayed that fresh steps may be allowed to be taken by such respondent. Prayer is allowed. Now, so for number 3, my lord,
No, there's no
specific order, but that can be passed because he has refused to take accept notice, and we filed an affidavit of service also to that effect.
It is also the assumption of Mr. General that as far as the respondent 2 and 3 respectively are concerned, this court, in a related application seeking continuation of delay in filing this instant appeal, had after due process submitted that has indicated that after due process the notice upon the respondent number 2 and 3 are deemed to have been served. However, such respondent failing to appear in court, this court, by relevant order, dated 18/2/2025, had directed that the proceedings be proceed ex parte against the respondent number 2, owner. Though no specific order to proceed ex parte against the respondent number 3 has been passed, the Learned Counsel has prayed that in view of the facts indicated from the records, this court may pass necessary orders to proceed ex parte against the respondent number 3. He is a driver.
Number 3 is driver.
Driver. On consideration of the submission made, this court is also of the view that no useful purpose will be served if the appellant is directed to take first steps on respondent number 2 and 3, who are the owner and the driver of the vehicle in question. Accordingly, this matter shall proceed ex parte against such respondents. Trial court record required?
Not required. Because my memo is self-contained, my lord.
Your memo appeal includes every aspect.
Yes, my lord.
Copies of deposition,
yes, my lord.
exhibits, so
Yes,
on
my
and
lord.
so forth.
The claim petition is there, WS is there, and the order is there. That I believe should be more than enough. Others, if
Because I
lordship,
recall in an earlier case, I think your friend was there.
I see.
We had, this court is required to go through certain evidence,
Okay,
not on record.
my lord. My lord, in that case, records can be called. This is from Tura. It will take some time to come.
And you file a informal paper book
Once the records are here, I'll prepare.
once the record comes.
Very well. Very well.
Because you see, naturally, in course of hearing,
Yes,
if certain facts is to be ascertained,
Very well. Very well.
then what happens?
Very well.
Matter gets stalled.
Very well. Records can be called. I'll prepare a paper book.
As paid for by the Learned Counsel, the records of the proceeding before the MSCT are hereby called for. This is matter after 3 weeks.
3 weeks. Obliged.
Item number 2.
कब फाइल किया था अनु?
What should we file a brief synopsis? We've already filed it.
I passed the. I prepared the order. I believe, you see, in the light of the Jagjit Singh case, the complainant, informant, complainant, survivor, victim has to be made a party.
Lordship.
The only deviation that this court has made is that the identity of even the informant, because it has to be kept,
Lordship, 228.
concealed.
Yes.
228A, of course,
Absolutely.
that refers to the victim as such.
Absolutely.
But here we're talking about informant and victims are
Two different things.
different
Yes.
persons.
Absolutely correct. Lordship.
the victim can also be the informant for that matter.
But yes, in a case where informer is different, then we have a different category.
But in POCSO cases, it's usually the parents or NGOs or whatever.
NGOs, yes.
So, but I have the view that even if their identity is revealed in the records, it would indirectly link. It
victim.
can be linked to the victim or the survivor. So, let me read out only the operative portion.
Lordship.
In the light of the relevant pronouncement in the Jagjit Singh case and the restrictions imposed by the Nipun Saxena case, this court is of the considered opinion that the informant, complainant, victim, survivor can be made a party in an application for grant of bail. However, his or her identity is to be confidentially kept secret, to be made known to the parties concerned only from the information available in the relevant records.
Lordship.
Under the circumstances, it is the direction of this court that the identity of such informant, complainant, victim, survivor to be revealed in the cause title of an application for grant of bail or the like can only be done so by way of an affixation of the character X, without revealing even the address of such party.
Lordship.
However, it would be incumbent upon the prosecution or the petitioner to cause issuance of notice upon such respondent through the investigating officer of the case, even if the case has proceeded for trial before the competent court of jurisdiction. The IO would then effect service personally or through a sign, and to further inform the noticee that legal aid can be availed if appearance for the court is so desired, or if engagement of a private counsel is not affordable. The above mentioned direction would be applicable not only to cases filed before this court, but also to all kind of cases filed before the trial courts. Correction to be made in the state of Meghalaya. Let copy of this order be issued upon all the sessions court and special courts also within the state of Meghalaya for due compliance.
Absolutely correct.
It would serve as a guidance.
Absolutely.
I mean, this would settle the issue once and for all.
Once for all, yes. At least we can straight away come back to the merit of the matter. Otherwise, this was the issue.
Now, in the light of this order, petitioner is directed to take necessary steps in accordance with the direction given herein.
Much obliged.
Item number 5.
Lordship, these matters have to make the same submissions only. It's still pending before the regional director.
You are not pursuing the matter.
We are pursuing.
Regional Director Shillong.
No, because regional director entire Northeast
No, where's the headquarter?
in Guwahati.
Guwahati is not far away from here. You can always pursue the matter.
We are pursuing till yesterday also. They have gone to the office, but necessary orders is yet to be passed. Well, this involves the entire Northeast where many companies are there also.
True. But the authorities have to be the relevant authorities have to be made known that there is a a pending matter
Your Lordship.
before this court, and this court
Your
cannot be
Lordship
made to
can make some kind of observation so that we can communicate the order to the authorities concerned. That is in respect of item number 5, Lordship.
only 5.
5. And in number 6, Your Lordship, because here the issue before this court was with regard to 13-14, but now it has transpired like there are many other years also there are discrepancies. So now they are trying to compound for the remaining years also, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22. So for that, they have to have a board resolution in item number 6. That has already been approved. Now they'll have to file applications before the ROC, and those applications, Your Lordship, has to be signed by all those past directors who have retired also. So it will take a cumbersome situation. So as of now, it's very much in progress. It may be done because of the law and order situation also in Manipur. It has crippled this particular matter.
Heard Mr. P. Nungri, learned counsel for the petitioner, who has submitted that the appropriate application before the ROC, I full form also, register of companies, is still pending, and in spite of due diligence employed by the petitioner, the matter has not yet come up for consideration before the said ROC. As such, it is prayed that some time may be allowed. Some more time may be allowed for the petitioner to apprise this court of the latest status of the matter. This court, on consideration of the submission made, has noted that this prayer has been, the same prayer has been made time and again over a very long period of time. Though this court would not interfere with the process before the relevant authorities, the petitioner is it is incumbent upon the petitioner to apprise the concerned authorities about the pendency of this petition and the fact that the same is required to be disposed of as early as possible. Accordingly, some more time is allowed for the petitioner to take necessary steps. How long? 2 weeks.
6 weeks.
This is matter of 6 weeks.
In the other matter, I was just praying for time, 6 weeks or so.
2, 6, 7.
Lordship.
6, 7, eh?
6 and 7.
As prayed for by the learned counsel for the petitioner, not objected to by the learned counsel for the respondent. This is matter after 6 weeks.
Obliged.
Item number 8.
Please, Your Lordship. Lordship, they had filed an additional affidavit bring on record the rules, Lordship. It was filed on 18.
Yes.
Sure, grant us 2 weeks time to at least to examine the rules, whether it'll have some application or not in the... I've not actually gone through the rules, but grant us 2 weeks time.
What have you brought on record?
The rules, Your Lordship, which have superseded the previous rules.
They
Your
have brought the new rules inside. The new rules itself, Lordship.
New rules have been notified, Your Lordship.
I'll just examine how much...
Heard Ms. Zedi Nogri, Leonard G, appearing for the state respondent, who has submitted that the state respondent has filed an additional affidavit dated 18/3/2025, wherein is annexed a copy of the Meghalaya School Service Rules 2025, which rules has effectively superseded the earlier rules made in this regard, and has submitted that the same may be considered at the time when the prayer made in this petition is to be heard, is to be taken up by this court. Mr. M.L. Nongpyo, Leonard Counsel for the petitioner, has submitted that copy of the said additional affidavit, including the said new rules have been furnished to the petitioner only recently. Dispute that some time may be allowed for the petitioner to respond to the same, if so required, even by way of a rejoinder.
Lordship, not necessary.
Not necessary, but that's
Just, Lordship.
the option given to you. But if you challenge the rules, then it'll be a different proceeding altogether.
Lordship, now the question, yes, Lordship. Now, so
Where is
far
the
as the
rule?
application of the rules also, whether it's retrospective, prospective, whether it'll apply to my case or not, just that aspect will examine, Lordship.
Tah. Belum tahu. Tak tahu dia. Ya, pernah tu. Great. Accordingly, this is matter of
2 weeks, Lordship.
2 weeks.
Obliged, Your Lordship.
Highly obliged.
Item number 9.
Give me the order. Indeed.
Yes.
May it please your Lordship. Lordship, this is a service matter, Lordship. The petitioner here was dismissed from service by dismissal order 14 January 2014, your Lordship, after the DP. The DP was conducted in 2013. And
Who are you?
I am the petitioner, your Lordship, and police constable in Meghalaya Police. I was enrolled in the job in 2002.
Yes.
And after rendering 12 years of services, the DP was drawn in 2013, and I was dismissed from service by DO, order dated 14 January 2014, your Lordship.
Just a moment.
The DP was 14 January 2014.
This is the impugn order.
Your Lordship, yes, Your Lordship. I'm coming there, Your Lordship. The first DP was drawn. I was dismissed from service, and
Where is the?
it is in my.
Where's the first DP?
Annexure 2, page number 21, Your Lordship, of the writ petition. Page 21, Your Lordship.
This order dated 14/1.
14/1/2014.
This is the first DP.
First DP, Your Lordship.
Yes.
My DP was done under the Repeal Act, Your Lordship. The Meghalaya Police Act 2010 came into force in 2011, February 2011. As such, being aggrieved, I approached this Honourable Court for quashing the DP. This Honourable Court was pleased to quash the first DP while order dated 5/4/2018 in page number 23, Your Lordship, Annexure 3, page number 23.
Yes.
And page number 25, Your Lordship, para number 6.
Yes.
Para number 6, Your Lordship, the Honourable High Court clearly directed, para number 6, Your Lordship,
Yes.
in that said order, the Shillong to instruct the department to conduct a fresh inquiry under the Meghalaya Police Act 2010, giving full opportunity to the petitioner to defend himself. Your Lordship, my DP was not drawn. Again, the second DP was drawn after a gap of nearly 1 year of this order, and my DP was drawn under the Meghalaya Service Conduct Rule, Your Lordship, not under any act. Not under any act, not under the Meghalaya Police Act 2010. And now again they are intending to dismiss from the service again, Your Lordship. So I came before this Honourable Court that my DP has been drawn, the second DP has been drawn by 26th March 2019 under the
Where is the second DP?
Second DP, Your Lordship, it is on Annexure 5, page number 35, Your Lordship.
March
26 March 2019.
This is second DP.
Second DP, Your Lordship.
26 March
2019. Your Lordship, though the Honourable High Court had directed to draw the DP under Meghalaya Police Act 2010, which was in existence, but they have drawn the DP under Rule 9 of Meghalaya Services Discipline and Appeal Rule 2011, read with Rule 66 of Assam Police Manual Part 3. The Assam Police Manual is not a manual under the Act 2010, and article of charges, which is in page number 37, Your Lordship. Page number 37 and 38, the article of charges.
Yes.
And in last line, Your Lordship, the charges has been drawn under Rule 3(1) of Meghalaya Service Conduct Rule 1990. The memorandum is being issued under Rule 9 of Meghalaya Service Discipline and Appeal Rule.
Yes.
And the charges of allegation has been given contrary to the memorandum in Meghalaya Service Conduct Rule 1990. Your Lordship, both the Meghalaya Services and Discipline Rule and Meghalaya Service Conduct Rule, both are the rule, Your Lordship. It's a guideline, but not at a penal section. So without penal section, without imposing penal section, I have been issued again the memorandum, and thereafter they are intending to dismiss me from the service.
After this, you see, after issuance of this article of charge,
yes, Your Lordship,
has the process been followed?
Yes, Your Lordship, I have given my.
You have responded? Have you filed your...
I have filed my show cause and all. I filed show cause, everything I did, but again they came to the conclusion at the last page, Your Lordship, of the petition, annexure 7, page 42.
Statement of imputation is here.
Your Lordship.
The statement of imputation is here.
Yes, Your Lordship. In last page, annexure 7, page 42, there penalty of dismissal from service may be imposed again, Your Lordship. So again they want to.
Just one. Page 42.
Page 42, Your Lordship.
Yes.
So here again they are intending to dismiss me from service without following the due procedure of law, Your Lordship. Earlier my DP was done, the first DP was done under Police Act 1861, Section 7, Your Lordship. The act was there, but in the 7 DP there is no act, Your Lordship. They are trying to dismiss me from the service under the rule. Rule is a guidelines, is not a penal section. Hence I approach this honorable court, Your Lordship, to set aside and quash the DP proceeding, entire DP proceeding, and order the department, the police department, to reinstate into service, Your Lordship. For that I have approached this honorable court. So whatever more than this, then I will reply to the submission of my learned senior lordship.
If I may take your lordship to the order dated 2/5/2024.
Order dated?
2nd May, your lordship.
Which?
2024.
Which?
No, lordship, from the order sheet. Sorry.
Order sheet.
See, the relevant paragraph would be para 6, but lordship can just go through para 1 to 3 hurriedly.
Just a minute. 2nd May.
2nd May, lordship.
Para 6.
Para 6 is relevant, lordship. All other queries that he has raised has been answered in para 1, 2, 3, 4, 5. But what is relevant is at para 6.
Yes. Yes.
Lordship. Now, after this court had passed an order, Lordship, and has directed us to produce a record on 21st May 2024. So the records, all the original records are here. We've been producing it time and again in the court. For some reason, the matter could not be heard. Now, what is relevant, very, very relevant, Your Lordship, is this. As per the record, Your Lordship, I'll take Your Lordship to answer the query. I'll take Your Lordship to the writ petition, the last page, page 42.
Yes.
No, the entire Lordship, the entire situation right now is it's stuck up at this stage of letter dated 18 November 2020 because of the pendency of this present writ petition. The department cannot proceed further because of in view of the observation in para 6. After remand against the second Shuka's notice, this petition is before this court to in order to enable the state government to produce the relevant records and present status of the disciplinary proceedings. So the status of the disciplinary proceedings, Lordship, we can't go ahead because of the pendency of the page 42 of the report. So there are two situations, Your Lordship. Either court grants us liberty to follow up and come to a conclusion.
So the disciplinary proceeding as such is not concluded.
No, not concluded. Not concluded. In terms of I read of the letter, Your Lordship. The further there is a requirement of notice.
Okay, no findings, no penalty imposed.
No, Lordship. So no, the situation I read of the detailed part of the page 40, Lordship. That is the stage it was stuck up. He'd been asked to file a objection to the proposed action to be taken under page 42. Now we could not go further, in spite of the fact the entire records are with us for more than 1 year now, because of this present situation. So if he approaches that particular authority, complying with that letter, and then we can come to a logical conclusion. If that happens, Your Lordship, then he may have a new cause of action. At this stage, Your Lordship, either court grants us liberty that pendency of this, we can conclude and then come back to court. A. B. Court says no, we dispose of this with the direction that conclude from the stage which is stopped, page 42, and then you still agree, please come back. So we are right now at this stage. That's why, Lordship, I read out the order of two.
Mr. Khan, see, you have pointed out to this page 42.
42, Lordship.
Now you lead this court through the process of the entire proceedings.
Lordship.
The step-by-step process. What is required? What has been done? What is yet to be done? And what is the stage? Where this page 42 figures.
Lordship, yes.
So tell me, I'm not so
Lordship, that is exactly the.
What do we start with?
Lordship, we started off with para.
Notice.
Lordship, yes.
As far as the DP is concerned, DP proceedings, I'm talking
Lordship,
about.
Lordship, yes. Second proceedings.
So first, second doesn't matter. We're talking generally.
Lordship, yes.
Now, first we start with the show cause being given to the delinquent.
Lordship.
Is it so?
Yes, Your Lordship. Lordship, if I may just assess the court page, if you leave page 42, Your Lordship, the brief synopsis of what has happened and what it has stopped is clearly in page 42.
Okay, you tell me.
Let us read page 42, Your Lordship. Sorry. So-and-so informed that the inquiry officer appointed to inquire into the charges against him has submitted a report. So the report was submitted, Your Lordship. A copy of the report inquiry is enclosed. Now this was given to him. He has received the copy to him. Next stage is on full consideration of the inquiry report, the undersigned agrees with the inquiry officer insofar as related to article of charge.
So article of charge to be?
Of the inquiry officer's article of charge. To be
drawn up.
Lordship.
That has been done.
Done. Further on scrutinizing all the records from the survey sheet of the delinquent, the undersigned has therefore provisionally come to the conclusion that the penalty of dismissal from the service may be imposed on so-and-so Shillong, considering his adamant attitude for not appearing before the EQ, requiring his presence to dispose of his evidence in connection with DP.
If I understand correctly, I may be wrong. After the inquiry, fine. Now article of charges drawn up.
Lordship.
Copy of statement of imputation.
Lordship.
Handed over to the delinquent.
Yes. It was an ex parte. It was ex parte proceeded.
Oh, ex parte proceeded.
Lordship, yes. Lordship will just come.
Have witnesses been examined?
Yes. Before the EU, his Lordship, just can you now allow me to just complete the sentence?
Okay.
For not appearing before the EU, requiring his presence to dispose his evidence in connection with instant DP conducted in accordance with the Honorable High Court of Meghalaya order dated 5/4/2018, and the same will be passed ex parte. He chose not to participate. So no, Lordship, the consequences is this: we had complied with the first round of litigation.
He chose not to participate.
Lordship, the first round of litigation was compliant with the High Court's order.
Has it proceeded ex parte?
As per this,
any presenting officer appointed?
That part, Lordship, only this particular order says it was inquiring the inquiry officers.
You see,
report.
it may proceed ex parte. Well,
yes,
that's a different matter.
Yes.
But I think the procedure demands
the presenting officer.
Presenting officer has to
yes.
Witnesses has to depose on the basis of such evidence. Then he comes to his conclusion.
Lordship, we are very grateful Now, supposing he has missed that opportunity, supposing, and those things there's a lapse on that, or it has oversight, we have not complied with it. Now, what has happened, Lordship, is kindly see the last paragraph. So and so, Shillong is hereby given an opportunity for making a representation on the penalty proposed.
But that is
No, Lordship, for a minute pause. Now, we are at this stage. No, he has got an option when he is given a chance to file a representation for the proposed penalty. He can raise the issue of presenting officer, he can raise the issue to set aside the ex parte, he can raise the issue evidence is to be late, and he can raise this issue because nobody is stopping him. It proceeded ex parte. Now, before imposing penalty, he's been also apprised. No, there is no bar on him. So we are stopped at the stage of proposed penalty. He can raise all the relevant issues, and if those are not addressed, then he's got a new cause of action.
And Mr. Kumar, I think that would be the correct approach. See, that would be the correct approach. Now,
Yes, Your Lordship.
you may be aggrieved by the procedure adopted.
Yes, Your Lordship.
It was not under the relevant rules and act and whatever.
Your Lordship.
But the fact remains that the proceeding is still continuing.
Yes, Your Lordship.
See, now it is only at the stage of the proposed penalty.
Your Lordship.
No penalty has been imposed on you.
Yes, Your Lordship.
No punishment has been inflicted on you.
Right, Your Lordship.
You have not been dismissed from service.
Yes, Your
You have not been, demoted, whatever,
Yes, Your Lordship.
for instance. So now what happened is,
I am under dismissal since 2014, Your Lordship.
whatever the case may be, now, if there are any lacuna in the process, it is incumbent upon you, as Mr. Khan has pointed out, to make an appropriate representation before the relevant or concerned authorities.
Your Lordship.
Let them deal with the matter. If you are aggrieved with that process, then perhaps you may come back to this court.
Yes, Your Lordship.
But this is not deciding your case. See, the
Lordship
court
is
cannot give you a clean sheet.
Absolutely correct.
Neither can it say that you are guilty,
Yes,
because the final order is not here. What we can do is this. You see, what we can do is this, without going to the merits of this matter. If you agree, we'll dispose of this matter with a direction to you to abide by this memorandum.
Yes,
Make a proper representation before the concerned authority.
Right.
All relevant facts that he wants to raise. Yes, it goes without saying. Yes.
Right, Your Lordship.
Why are we just lingering with the matter?
Yes. No, here actually I came on the low point, Your Lordship.
No point. You see, because no penalty has been
Yes,
inflicted.
yes,
You are
Your
still under suspension.
Suspension, but we are not getting anything, Your Lordship. We are
Subsistence allowance you are not getting.
nothing, Your Lordship.
That then you can make it, all those. You see, all those points of you can raise before the authorities.
Lordship.
If they refuse to abide or concede, you can always come back to this court on a different course of action.
Exactly.
Right, Your Lordship. The necessary order may be passed, Your Lordship, by giving some certain time, Your Lordship, 2 months or 3 months to dispose the DP.
Yeah, I'll give you 2 weeks time to file a representation.
Right, Your Lordship.
Thereafter, after 2 weeks, we'll give them 2 months time to dispose the whole proceedings.
Right, Your Lordship.
Provided he participates actively, otherwise he starts asking for time. That's the only issue.
We'll do it, Your Lordship.
then we'll have to also come back for extension of time. So a reasonable time, Your Lordship, maybe 3 months, Your Lordship, please. Kindly consider 3 months.
Right, Your Lordship.
And with the direction that he actively at least participate in his representation of whatever the case.
Heard. Mr. S. Kumar, Learned Counsel for the petitioner. Also heard Mr. K. Khan, Learned AG, along with Mr. S. Karolang and Mr. S. Sengupta, Learned Additional Senior Additional GA for the state respondent. In brief, the petitioner is aggrieved with the disciplinary proceedings instituted against him for alleged misconduct or misdemeanor on his part as far as his service is concerned. It is to be noted that the petitioner is police personnel in the Meghalaya Police Service in the rank of, what is your rank?
Constable, your lordship.
Rank of constable. The petitioner, being aggrieved with the proceedings conducted as far as the said DP is concerned, is finally aggrieved with the contents and implication and direction found in the memorandum issued by the Superintendent of Police and Disciplinary and Punishing Authority, East Khasiel, Shillong, dated 18 November 2020. Next, at this at the interjection of Mr. K. Khan, Leonard AG, what has been pointed out is that in the last para of the said memorandum, supra, the petitioner has been given an opportunity to making representation on the penalty proposed. This has not been done so. In fact, Mr. Khan has gone on to concede that if the petitioner is indeed aggrieved by the entire proceedings or part of such proceedings, he is at liberty. He is at liberty to make relevant representation before the concerned authority, which will be disposed of in due course in accordance with the relevant laws and rules. The Learned Counsel for the petitioner, on such concession being given, is agreeable to make such representation before the concerned authority and has sought for 2 weeks' time from this court to do so. Without going to the merits of this instant petition, on such consensus being on the submission of the respective counsel for the parties, this petition is hereby disposed of on the following terms. Number one, small line, that the petitioner would make a representation before the concerned authority to point out his grievance as far as the disciplinary proceeding against him, initiated against him, is concerned. Such representation to be made within 2 weeks from the date of receipt of this, receipt of a copy of this order. Number 2, on receipt of such representation, the relevant authorities are directed to take up the case of the petitioner, even if it requires institution of fresh proceedings, disciplinary proceeding. However, the same to be done so, to be concluded within 3 months from the date of receipt of the representation of the petitioner. Anything else?
And the liberty, your lordship, to come back again, file a fresh.
That goes without saying.
You see, Article 21 is available to
Yeah,
you.
that.
Lordship, only that representation in compliance with the page 42, Lordship.
Yes, I think that's what.
No,
Not representation in compliance with.
Lordship, yes, representation as per order dated page.
See, what this code would allow is for him to make a representation in general. If he is, aggrieved by the whole proceeding as such. So what you see, that would give you, the opportunity to start even a fresh proceedings.
The second part is okay, Lordship. The representation is compliance. Lordship is observed in the preceding paragraph.
Because if he is to make a representation in the light of this memorandum, then he is compelled to be under the process initiated,
And Lordship, with the liberty that he can raise other issues, so that liberty can always be given.
That is there.
But small requirement, Lordship. Please, because I'm relying on page 42, Lordship. So
representation.
The memorandum.
Yeah, ma'am. So I got to the petition is directed. As far as the.
With regard to this memorandum, your lordship.
As far as the requirement of of the said memorandum,
18 November 2020.
dated 18 November 2020 is concerned.
And that already we have filed, your lordship.
And then he can raise any other issues.
And he is also free to raise any other issues which, according to him, are relevant.
Lordship, that will include everything.
Then next. With the above, this petition is hereby disposed of, no cause.
उसका रिप्रेजेंटेशन मेमोरेंडम में दिया हो दिए थे पता नहीं दिया है दो बार दिया 42 का